And we want no mail-in ballots except for illness, disability, and military deployment or travel. We'll be very judicious. Look what's happening in California, where the ballots still aren't in. They're still not. Can you believe it? They're going to go for weeks and weeks and weeks. And you know what they do? They cheat. How many votes do we need? How many votes? That's why they take their time. How many votes do we need? Okay, here they are. Honestly, it's terrible. We're a third world country with elections.
It was President Donald Trump not too long ago talking about mail-in ballots and just when can those ballots be counted. 14 states and the District of Columbia allow mail-in ballots to be received after Election Day. In Illinois, mail-in ballots can be received up to 14 days after Election Day. And after a ruling today from the U.S. Supreme Court, those states can continue to count ballots that are postmarked on Election Day well after the election has ended. The case Watson versus Republican National Committee came down to a 5-4 decision Monday in the U.S. Supreme Court. The case centered around Mississippi's acceptance of mail-in ballots up to 5 days after Election Day, as long as the ballots are postmarked by that day. Now, joining us to discuss the latest is the Center Square reporter, Andrew Rice. Andrew, thanks for taking time with the states here, and you've been watching the Supreme Court, and still a few more cases to be released, but today they released a pretty big one. Tell us about it.
Right, Greg. As you mentioned, there are lots more cases to come with the Supreme Court, but this today was a really big one. Watson versus Republican National Committee. It was challenging this late receipt for mail-in ballots that you mentioned happens in 14 states and the District of Columbia. We had a really close decision in this, a 5-4 decision, which is just barely enough for a majority that kept it in favor of allowing states like Mississippi and others across the country, for example, California, Illinois, New Jersey, Virginia, New York, and many more, for allowing mail-in ballots to be received after Election Day, as long as they are postmarked by the Election Day. Now, Justice Amy Coney Barrett, she wrote in the court's majority opinion that the Constitution does not speak anywhere to requiring all of these ballots to be in by that federal election day. Just because there is this federal election day, which happens every the first Tuesday after that first Monday in November, that does not mean that these mail-in ballots have to be received by that point. They can be counted even days or weeks after that point. The other justices on the court, though, did really disagree with this. Justice Samuel Alito wrote, and Clarence Thomas, they wrote dissents in this decision, and were saying that this the court's interpretation of federal election day flies in the face of federal election statutes, and allowing ballots to be counted after this significant, momentous day is completely wrong, and it should not be allowed under federal election statutes. But obviously they were overruled here.
Yeah, more than a dozen states counting ballots after Election Day, and this was litigated, of course, through the federal judiciary going all the way up to the U.S. Supreme Court. Was one of several very controversial cases that have been covered extensively at thecentersquare.com. But let's look at some of what the justices on each side of this had to say. Coney Barrett, as you said, Justice Amy Coney Barrett saying the federal election day statutes do not preempt Mississippi's law because the defining element of an election has always been the electorate's choice of candidates. She further said that the Constitution requires the day on which the electors shall give their votes to be the same throughout the United States, but says nothing about the day for receipt. Again, Andrew, you read this argument, but you've also listened to the oral arguments that were had on this particular case. What were those saying that counting beyond Election Day is not fair? What were they saying?
Well, right. I've covered this case really from the beginning, from when the court said they were going to take it up the end of last year. They heard arguments for this case back in March, and it was a little surprise. It was a little surprising to some, especially some election integrity advocates that say this is not the decision we expected. It did seem, even from oral arguments back in March, that more of the justices were in favor of striking down some of these late mail-in ballot receipt deadlines. But that just goes to show that during these arguments, it's really hard to read the tea leaves in that sense. One argument that came from some people that were against the striking down of these late receipts was that there are laws that allow military and overseas voters to have their ballots received after an election day. And Justice Amy Coney Barrett, she addressed those directly. So different states across the country, like the ones that we've mentioned, allow these overseas and military voters to have their ballots counted after that election day. And she said that is one of many exact reasonings for why the court made its majority decision today, that to prevent from discrimination and discrepancy between general categories of voters compared to other voters that are overseas or military, submitting military ballots.
And this doesn't necessarily deal with mail-in ballots. The question really is about when can those mail-in ballots be counted? Is it only up to election day, or can it be up to 2 weeks, as is the case with Illinois? So I take it there's still going to be some head scratching. Well, what is the appropriate length? Is it 5 days after an election, or is it up to 14 days after an election? Didn't seem that was necessarily addressed. But as you stated, a 5-4 decision. This is a split court, and Justice Samuel Alito saying this in the dissenting opinion: if ballots received after election day are added to the set of ballots that dictates the election's outcome, the electorate's choice does not occur on election day, and the federal election day statutes are violated. So you can kind of see the differing opinions there, and that's why we have the nation's high courts to deal with these controversial issues. Andrew, we heard the president earlier on, several weeks ago, complaining about mail-in ballots. He put out a statement on Truth Social, essentially calling this a tremendous loss in the U.S. Supreme Court concerning what he said were voters' rights and the fact that people's votes are allowed to be counted long after an election's over. It is more important than ever to pass the Save America Act, which he says all voters must show photo ID, all voters must show proof of citizenship, and no mail-in ballots except illness, disability, military deployment, or travel. What other kinds of reaction are you seeing come in from this case today?
Well, exactly that. Like you said, Greg, President Trump is putting a lot of pressure on this for the Save America Act to be passed. And it is interesting and worth noting that this decision was still a narrow one. While it addressed this, Justice Amy Coney Barrett even said in her majority opinion that if Congress wants to make a change to the receipt of mail-in ballots, they can do it. And so it's going to be very interesting to follow further coverage of how the Save America Act continues through Congress. And it really does seem like many election integrity advocates are now pushing even further, if they weren't already pushing enough, that they're pushing further for the Save America Act to be passed. But then on the other side of the aisle, we are seeing a tremendous celebration for these and calling for other states to enact similar late mail-in ballot receipt deadlines. This is a trend that really began in earnest throughout the COVID-19 pandemic of the late mail-in ballot receipt deadline, just due to different concerns over the administration of an election. And a lot of across the political aisle and a lot of other voting advocates are saying more states need to take this up.
Yeah, but it's the minority amount of states that count those mail-in ballots after election day. I know some states, they still allow mail-in ballots, and it's pretty open as to what you can get a mail-in ballot for, but it has to be received by election day in a lot lot of other states. So, yeah, it'll be interesting to see how Congress handles this, especially with a little bit more clarity from the U.S. Supreme Court, which is kind of its role in a lot of these types of controversies. Andrew, several other cases released today. We don't have to go through all of these, but some of them dealt with the Trump administration's ability to fire people. What were some of the other cases that were released today?
Yes, those were some very interesting cases. We had, two cases about the Trump administration's ability to fire people. That's Trump versus Cook and Trump versus Slaughter. Trump versus Cook focused on President Trump attempting to fire Lisa Cook. She is a member of the Federal Reserve Board of Governors. That's the central bank for the United States. It's interesting, in this Cook case, the justices said that Lisa Cook should stay on her role and that the president does not have the authority to fire members of the central bank, citing the long, storied history of the Federal Reserve as America's independent central bank. Chief Justice John Roberts even said, in his opinion, cited the central bank's role during the American Revolution, or Revolutionary War, used to fund fighting forces against the British. So very timely as we're getting ready to celebrate 4th of July there. But then on the opposite end, we saw Trump versus Slaughter, a case where President Trump attempted to fire two Democratic appointed members of the Federal Trade Commission. And the Supreme Court said that President Trump had all the authority to do something like that for the FTC. That overruled a significant precedent going back to President Franklin Delano Roosevelt, and showed that executive agencies and executive boards like the Federal Trade Commission are under the president's purview. He can hire and fire at will. So that brings up a really interesting dynamic for how these executive agencies and boards will move forward in the future, and really highlights how an expanded amount of presidential authority for some boards, but limited in others, that won't just affect the remainder of President Trump's term, but future presidents moving forward.
And still some cases to be released from the U.S. Supreme Court, so be sure to get up to date with the very latest at thecentersquare.com. Thanks so much to Andrew for taking time with us. A couple other cases that were announced today include issues around warrantless wiretapping. We've got the new Civil Liberties Alliance announcing the court correctly recognizing the government's sweeping warrantless, suspicionless, and probable causeless collection of individuals' location history constitutes a Fourth Amendment search. Regardless of what that search actually turns up, the court's ruling, welcomed by civil libertarians as an affirmation that Carpenter v. United States was not an outlier, but a watershed decision. And so much more that you can find and stay up to date at thecentersquare.com.